I want to look at the rules relating to rejection of claims. These are in Rule 10 through to 12. The Employment Tribunal must reject the claim if it's not on the prescribed form or if it doesn't have each claimant's name and address and each respondent's name and address. That's Rule 10. It must also reject the claim if it's not accompanied by the fee or remission application. See Rule 11. The judge, on reference from the Employment Tribunal staff, considers whether or not there is jurisdiction to hear the matters set out in the complaint and whether or not the claim form is an abuse of process or whether it cannot sensibly be responded to. That's in Rule 12. What happens if you don't send the right fee? We're going to talk about fees later on, but if the fee paid is less than it ought to be, the tribunal gives notice of the date by which the full fee should be paid. Failure to do that means the claim or part of it in respect of which the full fee hasn't been paid will be rejected by the Employment Tribunal. If an application to remit the fee fails wholly or in part, the tribunal will send the claimant notice specifying the date for payment of the tribunal fee. The claim is rejected if the fee is not paid by that date. The form is returned to the claimant on rejection with notice of rejection explaining why it was rejected. The rules are in Rule 10.2, 11.4 and 12.3, which also refers to the need for the judge to give reasons. The notice contains information about how to apply for reconsideration. That's in Rule 10.2 and 12.3. But no such information is provided if the fee was absent. If the claimant applies in writing, giving reasons why the rejection was wrong and or rectifying the defect, then the tribunal can reconsider the rejection. If the claimant wants a hearing, the written application must ask for it, and if a hearing happens, only the claimant need attend. If the claimant doesn't seek a hearing, or the judge accepts that the claim should be accepted in full, then the judge determines the application without a hearing. That's Rule 13. However, if the judge decides that the original rejection was correct, but the defect has been rectified, the claim form is treated as presented on the date that the defect was rectified, and that rule, which will fix time for presentation of the claim, it is in Rule 13.4. Special rules apply to whistleblowing cases. If a claim form alleges that the claimant made a protected disclosure and the claimant consents, then under Rule 14 the tribunal can send a copy of the claim form to any of the regulators under the Public Interest Disclosure Prescribed Persons Order of 1999. So that's what can happen to the claim form.